As for the creation of an agency, there are several definitions. According to Section 139, the authority of an agent may be expressed or even implied in an agency. Express or implied agreement can form agency contract when no consideration is needed. According to Section 138, agency mentions that no consideration is necessary to create an agency. For example, the case of KG and Jaya Sundari and Berhad versus Pan Reliance Sundari and Berhad in 1996. It describes that the agency arrangement need not be in writing, since it doesn't need consideration to form an agency. This case describes that the Court of Appeal held that the law does not require that an agency or sub-agency agreement must be in writing. It also could be opposite. Furthermore, Part X of the Contracts Act 1950, which also contains the relevant provisions on agency, does not contain any requirement that the appointment of an agent or even sub-agent has to be in written form or be evidenced in writing. There are several methods to create an agency or to form an agency, which are agency by express agreement, by implied agreement, by ratification, agency by necessity, and also agency by estoppel. Let's see what are these agencies meant. Agency by express agreement, or even called as express authority, according to Section 140, happens when it's given words spoken or written communication stating that the nature of authority. It should be based on the appropriate construction of terms of the agreement. Agents are appointed by executing a formal attorney based on written and stamped documents, considered formal. Therefore, instructions from the principal must not be ambiguous, as the principal will bond his terms when the agent had clearly interpreted the instructions in a manner not intended by the principal. The case that were involved in this type of agreement is Ireland versus Livingston. In this case, the instructions from the principal was uncertain and it could be interpreted into multiple possible manners. Section 140 in Contract Act 1950 states that implied agreement happens when it is to be inferred from the circumstances of the case, where things spoken or written or even the ordinary course of dealing may be counted as circumstances of the cases. Agency by estoppels and agency of necessity are some of the cases in this type of agreement. There are two types of cases involved in this type of agreement, which are Chan Yin Thi vs. William Jacks and Co. Malaya Limited case, and also Haley Hutchinson vs. Brayhead Limited case. In the case of Chan Yin Thi vs. William Jacks and Co. Malaya Limited, 1964, the appellant and Young, who is a minor, were registered as partners. At a meeting with the representative of the respondent company, the appellant held himself out to be Young's partner. Goods were supplied to Young, but were not paid for. The respondent company obtained judgment against the appellant and Young. The appellant appealed to federal court, which held that since the appellant had held Young out of his agent, who had the authority to do things on his behalf, the appellant was liable for Young's act. As for the Haley Hutchinson vs. Brayhead Limited case, it shows that the creation of agency was happened through implication. The Court of Appeal held that Mr. Richards had authority to enter into the guarantee implied from the circumstances where he had entered various contracts on behalf of the company previously. The appeal court held that Lord Surdale had rights to claim the indemnity and guarantees because Mr. Richards from the company's conduct over several months, had the actual authority, being implied from the circumstances, to make those guarantees as the representative of the company. Therefore, the court held that although he wouldn't normally have authority to guarantee the loan, as he was entitled to believe that he was entitled to a loan. Therefore, it is considered as an implied agreement for the agency